more people who are, okay, we'll make a start. There will be more people who will be arriving, but if we make a start, so it's hello to everybody. It's a very warm welcome to this seminar on the first day of Paris Arbitration Week. My name is Peter Rocha, and I have the privilege of chairing our international arbitration practice at Reed Smith. I'm going to keep this introduction very short and just do three things. First, I'll share the inspiration for the topic of this seminar. Second, I'll explain the running order of what we'll be doing. And third, I will introduce very briefly our stellar panel of speakers. So the choice of the topic, summary dispositions in international arbitration, resulted out of one of our bi-monthly international arbitration video conferences, when we get together across our geographies and exchange ideas and share experiences. And Danny Avila, who's a senior associate from our Euston office, who's on the panel, made a presentation on the back of his dissertation for the LLM at Queen Mary's on this topic. And I won't spare his blushes. He got the top prize for his dissertation. But it was on the back of that that there was a very rich exchange of views around our network across different geographies, which really clearly illustrated that the topic is one that's fertile and that is very, very topical. So that was the inspiration for this. And without wishing to preempt the discussion that will come, we've had various instances, and a relatively recent one with a respondent state that have requested bifurcation of jurisdiction before the merits, arguing that the purported investor had acquired the claimant company for the precise purpose of bringing its pre-existing disputes, which were purely domestic, before an international tribunal. Well, the tribunal in that case actually denied bifurcation. Fast track, nearly 2.5, 3 years later, after multiple exchanges and memorials, after extensive document production, and after a 3-week evidentiary hearing, the tribunal finally produced a 300-page award and held in favor of the respondent state, and I'll let you guess on what basis: lack of jurisdiction. Right, we've divided this seminar into 2 parts. First, there's going to be an overview from the members of the panel, who will share their views and perspectives from their respective jurisdictions. And then we're going to follow that in our second part with a debate, when 2 of my partners have accepted to be pitched against each other in order to advocate a motion that's based on hypothetical situations. And my courageous partners are, well, there's Matthew Townsend, who's sitting on my left, and joining us virtually is Antonia Burt. Now, Antonia is based in our Dubai office, but she's actually out in Miami at the moment, so she's joining us very early in the morning. And Matthew is based in our Hong Kong office. You can't just sit back, so we're actually going to ask you to participate actively. And at the end of each of the pieces of advocacy, we're going to ask you, by going out to you with a poll, to say whether you were before or against the particular motion, and then we will get some views from other members of the panel. So that just leaves me very quickly to introduce our terrific panel today, and I'm going to do that in the order in which they will be speaking. So I start with Edna Sussman on my right, who's a renowned full-time arbitrator with experience in hundreds of complex arbitrations. Edna provides training to the American Arbitration Association's ICDR international arbitrators. Edna is also very well known for her experience in complex commercial mediations, and is certified as a mediator by the courts in New York and by the International Mediation Institute. Joining us virtually is Harriet O'Neill, and Harriet is a retired Associate Justice of the Supreme Court of Texas, and brings a wealth of judicial experience on the Supreme Court, and before that with the 14th District Courts of Appeal. Harriet sits as an arbitrator and mediator in complex multi-party cases. Now moving over to Stockholm, we have Stefan Brocker, who's at the end of this table, and Stefan is chairman of Mannheimer Swartling's shipping and transportation practice, specializes in domestic and international arbitration, and has acted as counsel in numerous arbitrations under the ICC answer trial, but also interestingly under the SCC rules. And that's interesting because, as Stefan will discuss, the SCC, of course, has specific provisions that relate to summary disposition. We also have from Switzerland, Felix Dasser, at the other end of the table, and Felix is president of ASSA, the Swiss Arbitration Association, and is a partner with the law firm Homburger. Felix has more than 30 years of experience arbitrating international commercial and investment disputes, and he is a renowned academic. There's Danny Avila, who I mentioned earlier, senior associate in our Houston office. Danny is part of our Latin American arbitration team. He's vice chair and chair-elect of the international law section of the Houston Bar Association. And last but by no means least is Patrick Bayton, who's NG's chief legal officer for mergers, acquisitions, and investments. Patrick will be known to a good number of us in the room and also participating virtually. Patrick's a member of the ICC Commission on Arbitration and ADR and has participated actively in several ICC task forces. And Patrick will be bringing some vital perspective from a critical part of our community, which is, of course, a user of arbitration services. So one last task before I hand over to our first speaker, Edna. We're going to already take a poll. In the room, if we could ask you to put your hands up if you're for, and virtually you will be able to do this electronically. And the question that we put to you is, have you or a counterparty ever attempted to request a summary disposition in a case? Hands up if you have experience. Okay, not that many actually, not that many. I don't know virtually what the, okay. Hi. Yeah, to read it. 68% no, and only 32% yes. Okay, which is actually pretty similar. It's probably even less in this room. Okay, well, I will shut up now and pass over to Edna.
Great. Thank you very much for inviting me. It's an honor to be here and a pleasure to see all of you. So, one always wonders how one should start one of these talks to capture the attention of the audience. And I thought maybe the best thing is to relate a personal anecdote. So I was at a side event and a conference, I don't know how many years ago, that was run by the ICC. And certainly the common perception then, and perhaps lingeringly so, given what's in the room, people didn't think that it was allowed to bring a dispositive or summary disposition motion in ICC cases. And it was a subject that I was very interested in. So I raised my hand and I asked Lexi, can you? And he was very surprised to hear the question. And he said, of course you can. And everybody in the room was really quite surprised to hear that. So I think, it is a subject that is very timely. I think it's changing. I think that historically people didn't bring such motions, A, because they didn't think they could, and B, because I think there's a feeling that the appeal rights are so limited when really felt that we should really give people a full opportunity to present their case and not preempt it. So I think it was a little bit of that psychology as well as feeling like I can't do it. I think, with all the new rules that have emerged since that time, specifically authorizing dispositive motions or summary disposition motions, that's changed. And I think there's been a real evolution in the thinking about the appropriate role of the arbitrator. Should we be a lot more proactive? Should we be thinking about the impact on the parties in terms of enabling them to settle the case maybe a little bit more quickly? And I call your attention to a survey that was conducted about 3 years ago. And the question that was put to really an international group of arbitrator practitioners and arbitrators, do you think an arbitrator has a role in fostering settlement? And somewhat surprisingly to me, 78% said yes. So what does that mean? It doesn't mean actually mediating, but there's so many things one can do as an arbitrator in terms of establishing a process, including allowing summary disposition motions to be made if appropriate to facilitate settlement. So I think that is part of why this is changing. It's both the new rules and the more proactive arbitrator that people are looking for. So turning to the US experience, because the US obviously has historically had in court proceedings, motion practice is very common. And in many cases, there are motions to dismiss that are filed to get rid of the whole case, to get rid of parts of the case. And then after all the discovery is done, then you see the motion for summary judgment. So there is a long and established history of dispositive motions, both at the beginning and towards the end of the case. So not surprisingly, the US, the AAA rules, I think were the first rules to actually specifically authorize bringing dispositive motions. So I think it was reaction both to court influence and because many of the, the corporations in the US said, why can't we do this in arbitration? We can do this in court. Why can't we bring a motion at the beginning where appropriate and dispose of the case? So in 2013, I believe this was the first that had specifically authorized, the first commercial rule, specifically authorizing it. So in 2013, the AAA rule said, you can bring the motion, we should permit the motion if it is, and the language is important because it does vary from rule to rule. And when you're looking at how it should be applied in a particular case that you're in, you should look at the specific rule. So the AAA rule said authorize motions likely to succeed and dispose of or narrow the issues in the case. So that's a pretty high threshold, likely to succeed. In the 22 rule, as they issued their new rules, they put in some more refinements, which I think you'll find in many of the rules now. So you have to consider whether it really does make the arbitration more efficient and economical. You're supposed to consider the time and the cost, and you can shift costs. So you can see the evolution in the thinking as there was experience with what the rule should say. Interestingly, the ICDR rule is a little bit different. It doesn't say likely to succeed. The threshold there is reasonable possibility of success. And I think it is important to look at how the particular phraseology of the rules read, because people read a lot into it. People are going to react very differently if you allow a motion that's likely to succeed as opposed to reasonable possibility. So I think one needs to really think about that and the reaction the parties would have. And do you want to give a false impression on a likely to succeed for something that's not likely to succeed? So the phraseology is important. So following the 2013 rule by the AAA, many jurisdictions have followed suit. Singapore, Stockholm, the ICC practice note, Hong Kong, LCIA. So I think at this point, many institutions have specific rules authorizing, and the ones that don't, I think one would assume, I think correctly, that the inherent authority of the arbitrator permits one to bring such a rule. And certainly the courts in the US confirmed that long before the AAA rule. We had an inherent authority to do that. So how do we do it? So it is something that is discussed at the first case management conference. And let's hear what they have to say. If they have a motion they would like to bring, talk it through. If it sounds ridiculous and it's just going to cost a lot of time and money and it clearly has fact issues, you can put a kibosh right there. If it sounds like it's definitely meritorious, potentially meritorious, I should say, and you want to permit it, you can build it right into the schedule at the beginning. If you're not sure, what we habitually do and what many of the courts in the US do is ask them to put in a 3-page letter. Put in a 3-page letter on why you think this is an appropriate motion, 3-page letter in opposition. You would be surprised how well informed you can be based on the 3-page letters as to whether or not the motion should be permitted to go forward. So that is kind of standard practice actually in arbitration seated in the US in terms of how to proceed. But we do make it very clear that we're not doing the US court process. We're not going to have successive motion to dismiss and summary judgments. This is not what we're doing. This is an arbitration, and we make that very clear. The kinds of issues that are raised at the beginning are the ones you would expect. Statute of limitations. Sometimes they actually say the contract is really unambiguous and you really can do this on a motion. And in rare cases, that's actually true. Res judicata, collateral estoppel, standing, waiver estoppel, failure to comply with notice procedures, contractual limitation of damages, no duty owed. The list can go on, but there are really quite a few specific kinds of issues that really often do lend themselves to early disposition. So why should people go through an entire case and time and money if it can be resolved early? So listen carefully, and if it sounds like it might really have merit, go for it. But you need to really think about whether it's going to dispose of the whole case. You know, I always say in court, often they will dismiss like a particular claim or particular legal theory. But I say in arbitration, if the rest of the case is basically going to be the same and they're just knocking out one legal theory, there's no point in making the motion. You might as well hear it all at the end. One of the questions arises is whether the arbitrator should be the one to raise an issue. Should you or shouldn't you, right? The IBA rules in a way kind of encourage you to do that, or at least they permit it. I think that's a serious judgment call. You know, if it's something that could be waived, you probably ought not to raise it. Some people favor it in terms of, you know, thinking that it's going to help the parties resolve. Real judgment call, you don't really want to put your thumb on the scale either. So I think that's, you know, that's something to think about long and hard. And if you're thinking about it and you have fellow arbitrators, talk to them before you pop out a question and make sure that you've kind of really thought it through, because that's not an easy one to decide. So bifurcation also comes up in this context, obviously, and you know, you need to think about the same kinds of issues there. Is it really going to, in the long run, save time and cost? Is it the same witnesses? Is it duplicative? And I think the one other thing that's a little bit different, I mean, jurisdiction, I think typically, if you can, you will try to resolve that early. But you might also think in the bifurcation context and the more traditional bifurcation that people request, which is between damages and liability, would it really enable a better damages analysis if it is bifurcated? Because there's so many times at the end of the hearing where you really need to talk to the experts some more, not that you've kind of thought it through. And if you bifurcate, it might actually help. So I guess don't be as scared of due process paranoia. And I'm supposed to wrap up here. I just want to say, what are the future drivers for utilization? So I think user preferences, I think a lot of corporations and a lot of users would really like to see arbitrations conducted more expeditiously and in a less costly fashion. And I think this is certainly something that can drive us to that outcome. So the show of hands showed very little utilization of this process, but I think we will see more of it. And I guess finally, in terms of drivers, we now have more competition in the international arbitration arena. So we now have this, so we really have to do a really good job of satisfying user demand, because we now have the Singapore Convention, so cross-border enforcement of mediated agreements. You've got the Choice of Courts Convention was quite new, which is beginning to get adopted, and the foreign judgments, the new Hague Convention on enforcing foreign judgments. So there are now many more avenues for enforcing cross-border dispute resolution solutions than just arbitration. And I think that's something that will foster a more receptive arena for these kinds of motions to be used. So I'm going to stop there and look forward to the other discussions.
Thank you very much, Edna. We move now to Harriet, who will also be dealing with the US perspective. Harriet?
Yes, well, first of all, thank you for having me here with this quite esteemed panel. I've had the pleasure of serving as an arbitrator with Edna Sussman, and I can say not only is she an exceptional intellect, she is very collaborative in her approach and a delight to work with. So thank you, Edna, for sharing your considerable experience here and for offering some good practical pointers. I've served as arbitrator in a number of international disputes, but today I'm going to discuss dispositive motions in the context of practice in the US. I'm going to talk about the types of motions that are available and the standards that apply to them, some drafting considerations for you to think about, some practice strategies you might consider, and my experience with the practice in general. Now, all arbitrators inevitably bring their own experiential lens to the process. That experience for me has been first in the courtroom as a business and commercial litigator, and then for close to 3 years as a trial court judge in Texas, followed by over 15 years as an appellate judge that focuses more on the law really than the facts. And now I'm back in the courtroom. My practice is pretty evenly divided between appellate work and arbitration, so I've come full circle. Through my experiential lens, dispositive motion practice is deeply entrenched. So it's frankly hard for me to envision arbitrating a case without asking whether or how dispositive motions might fit into the proceedings. It's certainly on my checklist of issues to discuss during the preliminary hearing. Now, when I started practicing law, I'm not going to go into how many years ago, dispositive motion practice was, I would say, very much in its infancy. not for lack of a rule granting judges that authority that had been on the books for a long time, but for lack of use, as it still may be, it looks like, in areas of international arbitration or with some arbitrators. Judges would let it be known that these motions were not favored, they were rarely granted. And I can say that that attitude has in fact changed, as Edna said. Courts are now very comfortable with granting dispositive motions when appropriate. We even have two types of summary motions. One is the traditional summary judgment, which you may be familiar with, where the movement attempts to defeat or prevail on a claim as a matter of law. The general standard requires the movement to show there's no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. In deciding whether to grant the motion, the court views the facts in the light most favorable to the non-movement. The second type is what we call a no evidence motion, where the movement argues there's no evidence, there are no facts to support one or more of the claim's required elements. A no evidence motion can only be filed after an adequate time for discovery has passed. The motion has to be specific as to the evidentiary challenge. You can't just lodge a general no evidence objection to a plaintiff's case. To defeat the motion, the non-movement is not required to marshal its proof. It simply has to point out evidence that supports the challenged element of the claim. Now, there was considerable controversy when the no evidence practice was first approved, but it is now firmly embedded in U.S. jurisprudence. I don't know if any of you have experienced such a creature in your arbitration practice. I have not, and whether a no evidence motion would be appropriate in that context would depend on the particular circumstances. I would think it would be fairly rare. But that leads me to a point I think is important, and that is the consummate source of the arbitrator's authority, the party's contract. The arbitration clause can provide for the filing of dispositive motions. It can state that the parties have the right to bring them, even no evidence motions. It can express that the parties do not have that right. That puts the decision in the party's hands rather than in the arbitrator's discretion. I've seen that done, but in my experience, it's the exception rather than the rule. I would say that if the parties do decide to cover dispositive motions in their arbitration clause, it would be a good idea for the clause to adopt by reference a specific set of rules governing disposition, so that can guide the parties' submissions and the arbitrator's deliberations. Now, if dispositive motions are not covered in the arbitration clause, one party can always seek the opponent's agreement to allow them, and that way a united front is presented to the arbitrator. Now, the arbitrator still has discretion not to allow it, but if both parties agree, then certainly the odds are much improved. Now, here's a practice pointer, one that I haven't seen used very much, and I'm not sure why, but for practitioners, if you request permission to file a dispositive motion and the other side successfully contests it, then track the legal fees spent on that issue during discovery and at the hearing. If the arbitrator rules in your favor on the point you wanted to present, you can seek to recover them as the prevailing party on that point. Even if you ultimately lose the case on the merits, you may be able to offset the prevailing party's fee award if the other side incurred unnecessary fees on an issue that could have been summarily adjudicated. So let's talk about the award. If a dispositive award is going to be reversed, it's most likely going to be on depriving a party of the opportunity to be heard and to present relevant and material evidence and argument. For that reason, if you, the arbitrator, are going to grant a motion, it's always best to spell out the reasons why in the award, even if it's only a partial disposition. Summary disposition should always be reasoned. Now, if a party wants to present argument on a motion, I generally allow it to make sure that the issue is fully presented and, frankly, to make sure that there's not something I've missed. But a hearing is not required. Often I'll tell the parties I'm satisfied with the briefing and ask if they'll agree for me to consider it on the briefing. And if they agree, then be sure to recite that in the award that they've agreed not to have a hearing. The failure to hold a hearing on the party's submissions has been held not to be a basis to vacate an award. But if a party wants an oral hearing and you decide not to allow it, it is best practice to say why in the award. If a party objects because the evidence isn't sufficiently developed, then explain why additional evidence would be immaterial to the legal issue that's presented, and it wouldn't have changed the result. Putting your substantive and procedural reasons into the award is the best way to protect it. Another practice pointer for practitioners, be sure when you're working on the scheduling order, and if you're going to include dispositive motion practice, put a deadline for the arbitrator or for the panel to rule on your motion. The last thing you want is for the disposition to linger. I've had a few cases, very few, where my ruling was to deny the motion at the present time, but I've expressed that the issue would be carried with the case. And that is a signal to the parties that I consider the particular point worthy of continued deliberation as the case proceeds. But again, that's wholly dependent on the circumstances. You also may want to consider a tiered summary judgment strategy. I am currently involved in a very complex reinsurance proceeding where choice of law and statute of limitations are an issue. We have set a briefing schedule for the choice of law issue. We have a date by which the panel will rule on that issue, followed by a discovery period, and then a briefing schedule and ruling date on limitations. This construct was carefully crafted with counsel to optimize their time and potentially streamline the proceeding, at least on a few key points. And this sort of staging, if done properly, can be very cost efficient. So let me talk about the threshold for allowing a dispositive motion. Edna touched on that. AAA Rule 34 says the moving party has to show the motion is likely to succeed. And to her point, it depends on the particular rules involved. The standard required in the AAA employment and consumer arbitration rules is substantial cause that a motion is likely to proceed. So you could consider likely to succeed as something less than substantial cause, more akin to a feasible or reasonable chance. It doesn't have to be a slam dunk. So let's say you think you've got a good shot, but you're doubtful the arbitrator will rule for you at this stage of the proceedings. But still, you'd like to use it as a vehicle to educate the arbitrator. Now, you're going to get differing views on this. Some say it's never appropriate to do that. Others say it depends. If the case is particularly complicated or will likely involve complex discovery issues, a dispositive motion may be a good opportunity to lay out a roadmap for the arbitrator about what lies ahead. Now, in cases where I've allowed but ultimately denied dispositive motions, I can't point to a one where I didn't find the educational exercise worth the effort later on down the road. And when it came time for the filing of pre-hearing briefs, the issues the dispositive motion addressed were incorporated by reference, so it was not wasted time. Now, that said, there are other ways to educate the arbitrator about the case. If that's your goal, you can make sure the pleadings are sufficiently detailed to provide the arbitrator a good understanding of those elements that are going to be hotly contested. You can request leave to conduct focused discovery on those elements. You can identify with opposing counsel early on the disputes you anticipate will arise and request leave to brief them up front with the right to file more fulsome briefs at their discovery window closes. So there are other ways to educate the arbitrator, but I would suggest a dispositive motion is a tool that you could consider. So what's been my experience? I would say that roughly half of my arbitrations have involved some sort of dispositive motion practice. I don't mean that one is filed, but at least it's been requested to be filed. I would approximate that out of those that have been filed, about 10 to 12% have been granted, none on the entire case, but on specific claims. And when that's been the case, I would say about a third of those have settled shortly after my ruling. So in sum, every case is different, and arbitrators should never cookie cutter their case management. There is no one size fits all. Dispositive motions will be helpful and appropriate in some cases, and they'll be counterproductive in others. I have found that the lawyers, by and large, have good handles on their cases, and they're the best resource for constructing a workable case management plan. The more time that's spent on that at the front end, the better the result at the back. I look forward to hearing the views and suggestions of others as we move forward through our discussions today, and I thank you for your time.
Thank you very much, Harriet. So now if we move from Texas to Stockholm with Stefan.
Thank you very much. Thank you for having me. It's a pleasure to be here with this panel and in front of this, I'm sure, very experienced audience. And it's also very nice to be in Paris. It was snowing when I left home, so it's good to be here. Legally defective or manifestly unsubstantiated claims brought before Swedish courts could easily be disposed of at a very early stage of a case. Even before a motion has been dismissed, even before the respondent has submitted any answer. The same has not been true for arbitration cases. Accordingly, the Arbitration Act does not provide any explicit provision empowering a tribunal with summary procedure. However, in 2017, the Arbitration Institute of the Stockholm Chamber of Commerce amended its rules and introduced Article 39 summary procedure. And I think I'm the only one who will be using the PowerPoint here because the rule is relatively detailed. So I will show it on screen to you if this works. Yeah. So Article 39 of the SEC rules, I will first show you the scope of the provision. A party may request that the arbitrator decide one or more issues of fact or law by way of summary procedure. So it applies to both facts and law. It applies to both claims and defenses. It is not limited in time. So the article is available to the parties and the tribunal throughout the arbitral proceedings. It may concern issue of jurisdiction, admissibility, or the merits, rather than providing a legal threshold or a legal test. The article provides three non-exhaustive examples. The first one you have on screen is where an allegation of fact or law material to the outcome of the case is manifestly unsustainable. So here you have two requirements. It has to be material to the outcome of the case, and it has to be manifestly unsustainable. Second example, which you have on screen, differs from the first one. There is no requirement of manifestly unsustainability. Rather, the tribunal will have to take as true the facts alleged by the non-requesting party. And if the defect is of a kind that will undermine the entire case, then there might be appropriate to use a summary procedure. The third example, finally, which you have on screen, is a catch-all provision where you don't have the manifest and sustainability requirement, and it does not have to be undermining the entire case. It could, in fact, be any issue material to the outcome where summary procedure might be appropriate. So much about the scope. The procedure of Article 39, you have subsection 3. As a starting point, the requesting party should specify the grounds relied on, the form of summary procedure, and also demonstrate that the procedure is efficient and appropriate. If those requirements are not fulfilled, the arbitral tribunal will not take the application further. If they are fulfilled, the arbitral tribunal will continue to the next step, which is the following, namely to offer the other party an opportunity to present its arguments. After that, the tribunal will take a decision either to dismiss the request or to set a form for the summary procedure. When doing that, the tribunal should, not surprisingly, consider all relevant circumstances and also the very purpose, of course, with the clause, namely to contribute to a more efficient and expeditious resolution of the dispute. Finally, there is in the clause a reminder of the important provision in Article 33 in the SEC rules, namely that both parties should have been given the opportunity to present their respective cases. That is a reminder of that the tribunal will have to consider that. So that is the article. And before I went to Paris, I asked my colleagues, and I also asked some practicing lawyers in other firms whether they have used this, and then some of them had. And I then asked them, have you used it successfully? And no one had. So I don't think that it has been used quite extensively, and it has not led to a lot of granting of these requests. I didn't know that there were any cases at all until I was thankfully reminded of that by Daniel Avila, who wrote a dissertation on this, and he showed me a couple of cases. One of those cases was where a request for summary procedure determining that Article 26 of the Energy Charter Treaty was not applicable to intra-European investments, and that request was denied. Another case, the respondent had alleged a couple of jurisdictional objections, also in investment arbitration. One of the objections was that there had been no investment, and accordingly the tribunal had no jurisdiction. That request was also denied, but was considered under bifurcation. And I think there was another case also which Daniel pointed to, but also in that case, the request was denied. So does this mean that the article has no value or so? I don't think so. I think it is a useful tool for arbitration panels. I think it is an effective management tool. And I think also that it has the possibility of narrowing down cases and facilitating for settlement. So it is a good tool, but you need more, I think, more bold arbitrators who are prepared to use it. So thank you.
Thank you very much. So from Sweden to Switzerland, Felix.
Thank you. That reminds me that people very often confuse Switzerland and Sweden and ask me about our capital, Stockholm, which is a nice city, but it's not the capital of Switzerland, which happens to be, who knows that? Bern, not Zurich. Anyway, we heard a lot about motion, practice dispositive motions in the US. And from my layman's view, I understand that dispositive motions have been developed in US civil procedure, not least in order to avoid jury trial and to avoid or minimize pretrial discovery. Now, these two enormously disruptive and enormously expensive concepts do not exist in arbitration. So the question is whether or not to copy those concepts into arbitration may actually render arbitration more efficient or rather less efficient. Now, first of all, we have to make a very clear distinction between two different concepts. One is bifurcation of proceedings. That's undisputed, it's not a problem, you can do it. It's spelled out in the Swiss Arbitration Act, but it's natural, it is a matter of course. Arbitrators do not have to wait until the very end to issue one single award dealing with all the issues. They can issue partial awards, they can issue preliminary awards. So bifurcation is possible. The question is whether it makes sense, but that's another question. The other thing is summary disposition of manifestly unmeritorious claims and defenses. And there we have an issue. Manifestly unmeritorious. Summary disposition. Now, summary disposition raises the issue whether the right to be heard was actually granted, and right to be heard is a mandatory requirement of arbitration. So you tinker with the right to be heard at your peril. Now, let me tell you about the UNCITRAL experience. Back in 2019, during the drafting of new expedited arbitration rules by the working group 2 of UNCITRAL, the idea came up of including specific procedural rules on early dismissal and preliminary determination. This was then separated from the expedited arbitration discussions because it was considered that it might be better placed for an inclusion into the general UNCITRAL arbitration rules. In 2021, Working Group 2 then started discussion on a detailed provision for a summary disposition, mainly of claims and issues that are manifestly without merit, and whether to include such a provision in the UNCITRAL arbitration rules. This also based on the fact that several arbitration rules already had such a provision. The question was, should we also do that for the UNCITRAL arbitration rules? From the outset, there was discussion pro and con. There were already at the outset some concerns. everybody agreed that it was within the inherent powers of the arbitral tribunal. The dispute was whether it was a good idea to highlight it by putting it into the rules and regulate it in detail. The Secretariat was tasked to lay out 3 options. First, a detailed rule to be included in the UNCITRAL arbitration rules. Secondly, a simple and generic rule to be included in the UNCITRAL arbitration rules. And thirdly, a detailed guidance text, not for inclusion in the arbitration rules. I participated at the discussions on behalf of ASA, and we submitted comments and recommendations essentially warning against the inclusion of additional rules on early dismissal and preliminary determination in the UNCITRAL arbitration rules. Because we said it's unwarranted and potentially even counterproductive. We, and also others, were concerned that an explicit inclusion would merely invite pleas that made the arbitration proceedings more time-consuming, more costly, instead of more efficient. We suggested that an addition to the UNCITRAL notes on organizing arbitral proceedings to inform about such inherent powers of arbitrators would suffice. Finally, the working group decided indeed to opt for the most unobtrusive option and to add a note number 21 to the UNCITRAL notes on organizing arbitral proceedings, simply to inform the arbitrators that they do have the power to actually grant summary disposition if they really think it is appropriate. But they should carefully weigh the pros and cons of taking such a step. Now it is up to the UNCITRAL Commission to consider and possibly adopt such a note in their next session in July. My assessment, I mean, lawyers are notorious gluttons. If you offer us options, we use them. The more, the merrier, right? I mean, anybody against? I mean, even if the chance of winning are limited, we are expected to use all the motions, all the options. Anecdotal evidence suggests, and we also heard today, that arbitrators are very reluctant to summarily dismiss claims and defenses at an early stage for being manifestly without merit. I mean, the large majority of such applications seem to have been dismissed, meaning time and money was spent for nothing. This is not in the interest of users. There are alternatives. First, I mean, counsel may simply not spend much money on manifestly unmeritorious marginal claims and defenses. This is more efficient than spending a lot of time and trying to convince unwilling and sometimes rather unprepared arbitrators that a claim or defense is manifestly without merit. Secondly, you can include mediation. More and more it is done in the East, maybe not yet in America, but also partly there, but in Eastern countries, also in Europe. And you can have ARB made up, for example, other concepts where you have such a possibility. And there's an efficient Swiss alternative that I'm happy to discuss. That is an unprejudicial preliminary assessment after the first exchange of briefs. Only if all the parties so wish. But then it's very efficient. After the first exchange of briefs, front-loaded, the arbitrators assess the case and they explain their initial assessment of the strengths and weaknesses of the parties' positions at an early stage. The parties can then assess their chances of eliminating the weaknesses with further allegations, further explanations, evidence. Often they prefer to settle. The Zurich Commercial Court uses this instrument very effectively. Each year, between 65 and 70% of all cases get settled during or in the wake of such a hearing. In arbitration, I mean, the parties need to consent and declare in writing that they would not use the preliminary assessment as a ground for challenging the arbitrators. Right? So this is an alternative, and of course, summary disposition is possible. My advice is, it's like medicine. Use it only when there is a real need, and then don't overdose. Thank you.
you very much. So now Danny will deal with some of the New York Convention issues which apply wherever you are around the globe.
Correct. As was explained earlier, I'm traveled here from Texas, where we ride our horses to work every day, as you might see. So I'll briefly cover the perceived concerns regarding alleged inconsistencies between Article 5 of the New York Convention and summary dispositions. Although summary dispositions are very common in Texas and the United States, they were not as welcomed in international arbitration, at least initially. This is because, and I don't know who's controlling the slides, can go to the next one. This is because of Article 5 of the New York Convention's language regarding a party's right to present its case, which we've heard from our panelists today. As many of us in the room may recall, the New York Convention on Enforcement of Foreign Arbitral Awards provides different grounds to refuse enforcement of an award. Article 5, 1B provides that a court can resist enforcement if a party was otherwise unable to present its case. Initially, the view of some practitioners in the international arbitration community was that a summary proceeding with no hearing and limited evidence could be inconsistent with this section. However, following growing concerns of inefficiency and cost and length of proceedings, the end users, that is, international arbitration practitioners, clients, and arbitrators, have pushed back at the need for an oral hearing to be aligned with the party's right to present its case. Parties did not want to keep these frivolous claims lingering in briefs and all the way to the final evidentiary hearing, which could distract the tribunal and the parties from the main issues at hand. Several surveys, including the 2013 PwC Corporate Choice in International Arbitration, the 2015 ICC Commission on Decision on Costs, and even the latest 2021 Queen Mary University International Arbitration Survey, all called for efficiency through dispositive motions. As we heard earlier, institutions such as the Stockholm Chamber of Commerce and the ICDR as well have provided new rules regarding dispositive motions, but more importantly, they've also included language regarding a party's right to present its case. Article 39.6 of the Stockholm Chamber of Commerce provides that considering summary dispositions, the tribunal should be giving each party an equal and reasonable opportunity to present its case. In the recent 2021 ICDR rules, included its first section on early disposition, but also included language that each party shall have the right to be heard and a fair opportunity to present its case. These are both prime examples of institutions also combating concerns that the summary dispositions are allegedly or perceived to be incompatible with the New York Convention. It should be noted that despite these institutions, including party's ability to present its case, it did not say, or the language did not include an oral hearing. So it's just showing that this presentment can be achieved through briefing the case. So again, there's growing consensus that parties' right to be heard can be via briefing and summary disposition. But as Justice O'Neill explained earlier, practically speaking, even if a tribunal felt that briefing alone was not sufficient, then it can certainly hold a minor oral hearing, even remotely, to allow the parties to also argue their points orally. So aside from addressing these concerns in the underlying arbitration agreement, these are just a few points and ways to be sure that the party will not later be able to argue that the arbitration award cannot be enforced. So those are the main points I wanted to cover regarding Article 5.
Okay, thanks very much, Danny. Well, Edna mentioned at the beginning that one of the key drivers is going to be user preferences. So let's hear directly from a user, and over to you, Patrick.
Thank you. Good afternoon. Thanks for having me. Well, a lot already has been said. It's most interesting. I can discern some not disagreements, but different views across the panel. So that's always a good thing. Let me start with a quote, and it's a quote from 2012 from Adam Raviv, who observed, and I'll quote, "The more meritless a case, the more likely that submitting it to arbitration will dispose of it less efficiently than resolving it in court." So let's assume we've been heading a long way since 10 years. Nevertheless, the Queen Mary surveys that you mentioned before, they consistently show that international arbitration, yes, is still the preferred way to solve international disputes, and by far, but nothing is perfect. And from a user perspective, or an end user perspective, or a client perspective, as some now start to say, most of the concerns expressed relate to efficiency. Commercial arbitration is often perceived as too expensive and too slow, and procedural rules are flexible indeed, but most of the time too complex. This has been confirmed in the most recent survey, 2022, on energy arbitration, where all parties said that they would like to see the arbitral process becoming more efficient. And many respondents noted a desire, I quote, to strengthen case management at the initial stages of the formal disputes process. It goes on, all, and if not all, most of them, of the respondents, believed that arbitrators were in the best position to hold parties' feet to the fire, quote again, to prevent mala fide delay tactics, to encourage narrow tailoring of arguments, and to provide avenues for summary disposal of claims, explicit in the survey. They followed on with interviews, as those familiar with the process know. And one of the respondents happens to be general counsel in a major global energy firm. It's not me. And he noted that there is a trend towards early and sometimes summary disposition of the so-called easier elements of disputes by arbitrators without the need for full hearings or witness testimony. And his feeling was that this proactive approach is almost universally what the parties want when it comes to arbitration. Now, what users, let's assume there's such a thing as users in general, what most of the users do want in abstracto needs to be distinguished, I think, from what an individual user put in a very specific situation would want to happen with his or her case. And when reflecting upon what would be good or less good for international arbitration, I think we would want to reason based on concrete experiences, but in abstracto. What is good for arbitration? How can we make it in general more efficient and less so in this or that particular case, I would like this or that. Because when debating those pros and cons, of course, we should not lose sight, and it's me speaking, you can quote me on this, we should not lose sight of the cynicism of in-house counsel and parties, cynicism that they either might profess or deny to profess, but when it comes to defending what we understand to be the short-term interests of our company in that particular instance. So let's try to reason in abstracto. Second question is, do we need explicit provisions? Frankly, I don't know. I'll leave it to the experts. It seems to me that an implicit provision might be sufficient in general for two reasons. One, as I said, most institutional rules are already complex enough. That is one. And second, for those of you who have experience not only in arbitration, but for instance in M&A or other big deal makings, when you're drafting, negotiating, and in the end ultimately agreeing on a dispute resolution clause, I think it's fair to say that the possibility for dispositive motions, and let alone the detailed procedural features of those provisions, is probably not the main concern you have right at that time. So it's interesting, but I'm not quite sure it has a dramatic impact in real life. And then third point, it was already alluded to, I think we definitely need bold arbitrators. Again, the survey of last year said that most respondents agree that the largest share of responsibility to expedite the process falls on arbitrators. And one question that arises out of this is whether the rules sufficiently empower arbitrators to make decisions at an early stage, or whether it is the arbitrators who might be reluctant to utilize the powers that they have been granted. And I'm afraid, at least that's the case in my experience, all too often it's the latter. And yes, bold moves, of course, can trigger post-arbitration judiciary disputes and reviews, but maybe that is the price to pay to have, in general, more efficient arbitral proceedings, and hence a sustainable alternative to the judiciary or other means of dispute resolution. So for me, clearly the benefits outweigh the drawbacks, albeit because if you have the possibility for dispositive motions, that may have a deterrent effect on those cynical in-house lawyers and external counsel who might be tempted to use other arguments.
Thank you very much, Patrick. There's certainly lots of food for thought there. Okay, well, this was the first part of the seminar today. We're now going to move on to do something that's a debate. And as I mentioned, two partners will be doing some advocacy on the basis of scenarios, and Danny is going to be moderating this.
Perfect. So we have two advocates. We have Matthew Townsend for, I guess, I'll discuss their positions after, but for one side, and Antonia Burt online for the other side. So I'll read the scenario first. They will provide their arguments on each side. Then you, as the audience, will answer whether you would or would not allow for a tribunal to grant a summary procedure, as in allow this situation to go into the summary procedure, not necessarily dismiss it all entirely. And then we would go to our external speakers to get their thoughts. So the first scenario, as you see on the screen, I don't know if they got it, is claimant renewable energy, REC, enters into a wind turbine agreement, TCA, with supplier wind company for supply and commissioning of certain turbines off the coast of Sandwood Bay, UK. REC alleges that several of the turbines failed at the wind farms 4 years after commissioning, and brings an arbitration against SWC, claiming a variety of damages, including lost profits under theories of local English law after negotiations fail. Respondent SWC files a request for early determination, seeking a determination that the limitation of damages clause and the TSA limited several of the claimed damages, if not all, and arguing that an early disposition of the clause being applicable would save the tribunal and the parties expensive briefing and presenting extensive and expensive expert testimony. So I guess we'll start off with Mr. Townsend, who is for early dispositions, for your position on this.
Well, good afternoon, Mr. Arbitrator, seated rather unconventionally to my left. I represent the respondent, which is in turn represented by the round red circle, SWC, in seeking early determination of our defense that the contract, the TSA, limits the claimant's damages to exclude lost profits. And this is a limitation we say that so obviously applies that any arguments made by my friend to the contrary would be manifestly without merit. So I'll make 3 points in my 5 or so minutes. First, that this issue of lost profits will be very expensive, time-consuming to litigate. Second, that these costs and this delay will be unnecessary and can be avoided by an early determination if the tribunal is minded to order it. And then third, that this case otherwise allows, in this case, I should say, early determination otherwise allows for a fair and expeditious arbitration. So let's go first to my initial point, that lost profits in this case will be extremely expensive and will lead to considerable delay in litigating. Now, as it stands, as the tribunal has just set out, we have a multi-year contract we have turbines which have allegedly failed during the fourth or the fifth year of this contract, with several years left during the life of the contract. And so any assessment of damages on a lost profits basis will lead to, we would say, considerable debate. And perhaps I can paint a picture for you. You would have considerable debate as to the electricity prices, which would be achievable throughout the many years left to run in this contract. That involves experts discussing the market changes in the energy market. It might involve, God forbid, experts hypothecating about potential regulation and the impact that might have on prices. But that's only the first dimension. The second dimension, of course, is the electricity production levels to which these prices will apply. Mr. Tribunal, Mr. Arbitrator even, are you familiar with the diurnal cycle when it comes to wind patterns? I fear that if we are to proceed with this arbitration in this way, you will become very familiar with that term. What about the impact of climate change on future wind turbines? It may be that the experts that the respondent has appointed and the claimant's experts are of one mind on this point. I suspect they will not be. And how about the cost of maintaining within this discounted cash flow methodology model? What about the cost of maintaining these turbines? Now, our appointed expert has not had a chance to look very closely at the documents, but he is absolutely convinced that they will be cripplingly expensive to maintain. And any impact on the amount of lost profits there is purely coincidental. Now, what about, and that of course only covers the inputs into these into this model and this assessment of lost profits, which will become a key part of the arbitration. Now, our quantum experts are currently busy at Paris Arbitration Week discussing geopolitics and diversity. But when they turn their minds to the question of discount rate to be applicable to the DCF, I suspect that they will have quite a lot to say. The same goes for the beta. I mean, my experts tells me that our beta is unimpeachable. I do not know if my friends' experts will agree to that. And what this means in sum, the point is that if we are to litigate this lost profits question, we will need evidence from witnesses, industry experts, meteorologists, quantum experts, and there will be a good deal of scrutiny of any evidence offered by these experts. And this will be a long and time-consuming, well, a time-consuming and expensive process. And that takes me to the key point, which is this expenditure is unnecessary and will be avoided by an early determination that lost profits is an excluded form of damages. If the early determination process allows, or if the early determination is granted in the respondent's, my client's favor, then all of this expense can be avoided and the claimed damages can be advanced on the basis it should be advanced, which is on a much simpler and a much lower basis. The multiple pages of reports that I've just mentioned will go unread. Expert joint meetings will go unconvened, and we may all go to our graves without having to consider the regulatory impact on energy prices in 2025. So to summarize, early determination is appropriate given the cost of litigating the lost profit question and the fact that it can be avoided if a tribunal finds for us on early determination. And that concludes my submission.
Thank you so much. And Mrs. Burt, you have the floor.
Thank you. My name is Antonia Bird, and I'll be representing the claimant, Renewable Energy Company, in this application. The claimant's in the business of providing renewable energy to European households, an honorable pursuit in the fight of the biggest threat humanity currently faces, the climate change. Claimant's not in the business of dispute resolution proceedings. Yet nonetheless, claimant finds itself in this unfortunate position of having to detract valuable resources from saving the world to pursuing its rights against respondent. The tribunal will be fully briefed in due course, once this pesky application is out of the way, of course, that respondent has supplied faulty wind turbines. And on that basis, it has breached the parties' agreement. This is a serious issue which must be heard and one which must be compensated with an order for damages. Several heads of damages have been claimed in these proceedings, lost profits that my learned friend focused on being just one of those. Rather than addressing the key issues in dispute, respondent is now hiding behind alleged contractual limitation of damages provisions, and on that basis seeking to bifurcate proceedings. Respondent's actions, however, speak louder than words. It knows it will lose on liability and hence is now jumping ahead to the consideration of damages. In these short submissions, I will elaborate on 3 reasons why respondent's application must be denied. And first, starting with respondent's first main argument today, that the bifurcation would make the proceedings more efficient. That simply does not stand. Respondent is putting the cart before the horse to argue that a limitation liability provision limits the damages and then wishes to deal with the merits later. This is problematic for several reasons. Even on respondent's own case, and I quote from learned friend's submissions, the limitation of damages clause limits several of the alleged damages, if not all. Respondent's primary argument, therefore, is not that the limitation provisions limit all claims and heads of loss. However, unless all claims are excluded entirely, there will need to be a merits phase, and there will need to be a damages assessment. Bifurcation of this limitation liability issue will therefore increase overall costs and time spent on these proceedings by splitting out an issue which does not in itself limit the remaining proceedings. Respondent's cart before the horse approach also doesn't work because the issue of limitation of damages is interconnected with the merits of the claims. And for this reason, again, an early determination would deprive the claimant of its due process rights. And this is why, unless the tribunal hears the claims, it cannot decide whether to limit such yet undetermined claims. Again, in earlier submissions, only lost profits have been addressed. However, as we know, several of the alleged claims are said to be limited by the liability provisions. But of course, those claims have not yet been addressed or heard. Until the tribunal hears the claims and it cannot decide whether such yet undetermined claims are limited. The interpretation of the limitation provisions and which claims such provisions may or may not limit, as well as the applicable law, requires a detailed analysis of the claims. In other words, it's impossible to limit something which has not yet been pled or determined. If the tribunal decided to limit claims before it heard the merits of them, which would be frankly preposterous, the tribunal would deprive the claimant of its due process rights. Claimant is entitled to put its positive case forward before any issues of limitation are considered. And finally, probably most decisively, the respondent's chances of success limiting all claims in these proceedings purely on the basis of the limitation provisions are fanciful at best. While not yet fully briefed on the issue, the extremely experienced tribunal will be well aware that contractual limitation provisions rarely if ever limit all genuine claims, which may of course also be made out in law. And indeed, as already addressed, respondent does not even argue as much, today only focusing on one of the heads of claims. Authorities on the record confirm that an unsuccessful bifurcation, which is what would ensue here, will only prolong the overall proceedings and hence prolong the time that claimant must divert attention from saving the world. That's unacceptable. To conclude, I reiterate the claimant's commitment to a fair, efficient, and cost-effective resolution of the dispute, which can only be achieved if the tribunal rejects this application.
All right, so the first poll question to the audience, and if they can put it in the audience online, is this situation, this limitation of damages clause, should it be decided by a tribunal in a summary procedure? So I guess a show of hands, if yes, it should be considered for summary procedure, and hands down if no, it should not be considered for summary procedure.
But bear in mind who's in the room.
Yes, sir. 2, 3, 4. Lucy, are you getting these down?
I think I've lost.
You've lost in the room, yeah.
And Antonio succeeded.
Okay, so now we'll turn it
Electronically.
electronically, or? No, it should not be. Okay, so now we'll turn to Mr. Brocker, if you want to give your thoughts on this scenario.
I think I will vote with the audience. Well, I think that I'm going to assess first the one part of the quantum before you have even assessed the liability. I think that would be kind of backward. I also think that it is a, we heard that you would only deal with one out of several claims, which is also, I think, a reason. I mean, in my thinking, you should use a summary procedure where you have a crystal clear case where you actually dispose, if not the entire, but the majority of the claim, or at least an isolated issue. And I don't think you fulfill that here. So I think that I would deny that request.
All right.
Any other differences of opinion?
Yes, that's what I was gonna ask.
Well, I guess I go next, so why don't you pose the next typo, and then
Okay.
I can do it in that
Okay.
context.
All right, so that was hypo number 1. Hypo number 1A is the same hypo, but now the claimant argues that a clause is inoperative because of local law, because the respondent acted with gross negligence.
Thank you very much. I can see from the tribunal's demeanor that he has been thoroughly convinced by my arguments so far. Now, as the position has changed somewhat, the respondent's view remains that it is still appropriate to have a summary disposition of this issue, even though the claimant now argues that the clause in question, the limitation clause, is inoperative under local law due to alleged gross negligence of the respondent, gross negligence, which is of course denied. Now, it is true that in the early determination proceedings, some factual evidence will need to be led now on this gross negligence point in order to ascertain whether or not the claimant's contentions are correct. Of course, we say they're not. And it is therefore true also that the leading of this additional evidence will mean that the case management perspective, from a case management perspective, the early determination proceedings are a little bit more cumbersome. They will involve a little bit more material. However, in our view, this burden is outweighed by the benefits of early determination. And I will very quickly go again to what I think is the key benefit here, which is an early determination of whether lost profits are excluded is in effect an early determination of what kind of arbitration we're having here. It will be a determination of the complexion of this arbitration. Are we having the kind of arbitration where we will need to lead the masses of expert evidence that I described earlier? Or will we be in an arbitration in which the amount in dispute is potentially rather smaller because it will be under the smaller heads of claim? And in this regard, I believe the tribunal will remember my friend's analogy of the putting the cart before the horse in determining the amount of and determining issues of quantum first and liability second. But Mr. Arbitrator, I think she's being rather cruel to the horse in this instance, because she considers that the cart should be a double-decker bus, whereas we consider the cart should be something rather smaller. Therefore, I think this is quite an appropriate case of putting the horse before the cart, purely for the horse's health and safety. So that concludes my short submission on that point.
Okay, Mrs. Burt.
Thank you. To request bifurcation on this issue in circumstances when the clause is inoperative due to the respondent's gross negligence does not even pass the red face test. If this matter was to be bifurcated, it would require significant documentary and witness evidence, as respondent's counsel accepts, to show respondent's gross negligence. This issue would be entirely interlinked with the merits of the claims. Showing the gross negligence would relate to the same issues that would need to be shown with respect to the breaches of the agreement. And hence, rather than leading to any kind of efficiencies, such a bifurcation would cause duplication. I would say that the horse would have to carry quite a lot more on the cart, to use my friend's adaptation of the analogy. This is just not an issue which can be sensibly heard as a preliminary basis. It risks inconsistent decisions. Any bifurcated proceedings would require the tribunal to issue a final partial award on the issues before it. However, later merits proceedings would address the same or related factual questions. This is just not acceptable. And as such, this request must be seen for what it is, respondent's dilatory tactic, and it should be denied.
Okay, so back to the audience. Should this situation, now slightly modified with gross negligence being alleged by the claimant, should this be submitted to summary disposition for consideration?
Your faithful point of view.
Do you have a
Oh, thank you very much. Yeah.
You have two friends in the room.
Yeah, and myself, yeah, three.
Okay, you want to show the online one?
Do you sit as arbitrator, sir?
No. So I kind of wanted, I'm going to switch up just slightly. Hopefully Peter won't get mad at me. Is Justice O'Neill or Arbitrator Sussman, for the first hypothetical, do you see any situation, do you see this at all, if it's a pure question of law, appropriate for summary disposition?
Yeah, I mean, let me jump in. I think, I don't know, Harry, you want to go first? Go ahead.
It doesn't matter. You go. Go ahead.
No, I was just going to say that, one of the things that, really emerged a little bit from the impact that allowing the motion has had in settlement. I think Harry had said 30% of her cases have resolved. And I think, down there in preliminary views, Felix said it resolves what, I think 50%, he said. So I think one of the things one needs to consider in the context of whether or not to allow a motion to be made is what the impact might be on the parties settling, whether it's, in favor or against in the end. And, we did do yet another survey. So the polling, 80% of the polling respondents said that the arbitrator should consider the impact on settlement and deciding whether to allow preliminary motions to be made. So, there's a little bit of a sort of a judgment call one has to make here, because one can also give the false impression that you think it's a meritorious motion when you really think it's not, and people will settle on a basis that's probably is not really reflective of what you actually view the merits to be. On the other hand, sometimes you feel like they really need the answer to that issue in order to get to a settlement. I mean, I had 2 cases last year where we permitted the motion to be made. And one was, just interpret the contract. It's really straightforward. And actually both parties wanted to have that submitted. And the other one was a failure to give notice in accordance with the contract. And they both settled before the resolution of that issue by the tribunal. Just having that laid out for the parties early on, pretty much in depth, caused them to settle long before we got to any of these other proceedings. So it really can often drive settlement. And that's something to weigh sort of, yes, I should I, whether you should or shouldn't is just something to think about. I think one of the things that wasn't mentioned and that I was surprised to hear in the course of, some of talking to people around the world, there are some places where that kind of partial award or disposition of a single issue allows people to take it to court immediately. Well, that certainly is not going to be shorter and quicker. So if it's likely to be in a jurisdiction where they can take it up to court right away, you probably think long and hard about whether you do it, because that's certainly not a productive way to proceed. And I guess the last thing I want to talk about is what you write. And Harriet referred to this a little bit. And some of the rules specifically say you have to give the reasons for your award, although some of them say summary fashion. So I would say if you're granting it, clearly you have to explain why with, the way you would any other award. If you're denying it, there is really a split in how one goes about this. Some people are wary of really writing much in terms of the denial, other than, their fact issues, I can't do it, because sometimes you might regret what you write as you learn more about the case later. And it's kind of hard to go back and say something different. So one is a little cautious about what one puts down in paper before you see everything when you're denying. On the other hand, I've had counsel say, you got to be kidding. I spent all this time and money on this motion. I want to know what you're thinking. You should really explain why you're denying it. So I'm not telling you what to do. There are 2 points of view on that. And maybe it depends on the case, like everything else in the world. But, one can go either way on the denial. Clearly, you have to write it up, as Harriet said, if you're granting.
Yeah, I would say several points. At first, let me just, I would deny it on the gross negligence piece. If that's at issue, it's hard for me to see how that could be parsed out on liability. But I love, and another thing is a semantic point. I think in US practice, this would be called a motion, a dispositive motion, rather than a bifurcation. So bifurcation sort of connotes you're going to go ahead and litigate the issue and decide it separately. Whereas dispositive motion is a matter of law determination. I love this example because I have run into this very question a number of times in some of my complex arbitrations. I've run into it as an appellate court judge deciding these very issues. The typical damages limitation provision prohibits the recovery of consequential damages. So the issue is whether lost profits qualify as direct or consequential damages. That's a question of law, but it might be a question of law that depends on the facts. It's surprising how unsettled the law can be on this topic. So the question I would want to ask, and I might invite a 3-page request on this issue, is how much will the characterization of these damages as consequential or direct depend on the facts of the case? And if that's going to be a fact-intensive inquiry, I might allow a short brief on that in the dispositive motion so I can direct my attention throughout the proceedings on that. But I think that would be more appropriate in a pre-hearing brief as opposed to a dispositive motion. But those are the type of questions I would ask: is how fact-intensive is that determination? If it's fairly clear that these are going to be consequential damages that this limitation provision would bar, I would allow the filing of a dispositive motion, because in my experience, lost profits damages are very expert witness intensive and can take up a lot of time. And if the limitations clause wipes them out, then I would go ahead and allow the motion.
All right, so now looking at this sub hypo with the gross negligence, we got good thoughts on it, but I guess Mr. Brocker, I think you had a couple points that you wanted to add.
I was just thinking, I mean, I would agree, I would deny that as well, but I remember we have been sitting in an arbitral tribunal where there had been a claim for damages and where the other party had raised the defense that it was no limitation of liability because of gross negligence. And in that case, the facts were established. And we were sort of in the middle of the arbitration. The facts were more or less agreed upon. The only question was whether those facts amounted to gross negligence under Swedish law. We didn't issue an order at that time, but we asked the parties whether they would like to hear the arbitral tribunal's view on that matter. And they said yes. And we told the parties that gross negligence has not been established. And then they settled the case. So that's, I think, a Swiss variant on
Yeah,
that.
that's
So.
interesting. Okay, so now new hypo, same as the first one, but now nearly 90% of the damages are, I guess, wiped away or removed if early, let me rephrase this. So same hypo as the first one, but the early determination applies to 90% of the damages. Now, I'm gonna switch it up now. Mrs. Burt, you have the floor first.
Thank you. Bifurcation of the issue of limitation of liability in a situation where not all damages will be limited is not an efficient use of the tribunal's time for the reasons previously communicated, even if the respondent is successful, which of course is very improbable. The merits of the claims will need to be heard, as there will be still some remaining damages, even on respondent's best case. And therefore, it is a better use of the tribunals and the parties' valuable resources to hear the issues in a unified proceeding, which will allow the tribunal an opportunity to first appreciate the extent of respondents' wrongdoing before deciding whether some of the wrongdoing, even if it's 90% of it, must be limited by the contractual provisions. This would give the claimant an opportunity to be heard and hence preserve its due process rights.
Okay, Mr. Townsend?
Thank you very much, Mr. Arbitrator. I can see that while you started off warm to me, you are becoming progressively warmer as the afternoon goes on. I have two arguments here. The first is the argument I've been making previously, which is cost and efficiency. And early determination is still appropriate because it saves cost. And the alternative to having early determination is a poor use of the tribunal's and the parties' resources, because the parties are in real danger, we say, of running this case as if it is a large case when it is in fact a small case. I mean, at the risk of oversimplifying it, you would not jump off a wall if you did not know how high that wall was. So that's the first point. But the second point is a point that's occurred to me fairly recently. I've become quite a new convert to this point, and that is that there is a potential that merely by hearing the arguments on this point early, it could become a driver to settlement. This is a rather complex case. Sometimes, obviously not, it is quite possible in this case that the parties have not quite got to the point of focusing their minds on the precise figures in dispute. And by debating an issue that goes to the quantum of the dispute, it might be that this is quite the prompt for the parties to start focusing upon that point. So it's an efficiency point first, but you never know, we might get a settlement out of it, Mr. Arbitrator.
Okay, so now to the audience. Now with the new hypo, 90% of the damages, who would allow or not allow, but address the issue in summary disposition? Four. Okay. And online? Yes. Okay, so we have our first yes of the day. At least online. So we'll turn this to arbitrator Sussman. What would you like to add a couple?
Yeah, it sounds like people are beginning to hear this idea that it's going to drive settlement, and that's what they're responding to perhaps in this very different response that we're hearing. So I guess I want to say yes, and I guess that's what I started saying before. It does often drive settlement, as I two of my cases settled just with the filing. We didn't even have to make the decision. But one has to color that a little bit. They can be very expensive and very time consuming. So, we don't want to overplay how important it is to allow a lot of these motions to be made. It really is a judgment call every time. So thinking about the possibility of it enhancing settlement is certainly part of that equation, but it's not at the expense of continuing to think about the time and cost of these motions, because they're not cost free and they can really slow down the process. But as I said, if you bring it up at the first case management conference and try to get a feel for it either on the spot or through these 3-page letters and build it in so it is resolved quickly. Some of these rules actually have provisions as to how quickly one needs to decide whether there should be a motion, and even how quickly one needs to decide the motion. So it doesn't necessarily take up a lot of time, but they can be expensive, both in terms of counsel preparing it and in terms of the arbitrators deciding it. So it's not for every case and not for every motion. Don't get the wrong idea. But, you have to use your intuition. We all have our feelers out for what's going on, what the parties are thinking, what's going to be helpful to them. And so sometimes you might allow a motion to be made that you probably think is really not so meritorious, but you get the sense they need the answer to that question to move forward and resolve. So use your intuition and, get those feelers out and see what you think is going to be helpful to the parties.
Okay, last sub hypo in this first scenario. Instead of 90%, now it drops down to 10% of the damages. Mr. Townsend?
Mr. Arbitrator, early determination is still appropriate, even though the limitation now only applies to 10% of the total damages claimed. And Mr. Arbitrator, this is because there needs to be a key distinction made here, which is just because this is an issue which is related to a small proportion of quantum does not mean that it is not an expensive issue to debate. In fact, our position is that any disproportionality whereby the parties end up spending a large amount of money and resources in debating a point of low importance or low significance to the outcome, that is another reason for why that issue should be dispensed with early. So those are my submissions on that point.
Okay, Mrs. Bird?
Thank you. Mr. Arbitrator, this is an unarguable request and it should never have been raised. Engaging in lengthy motion proceedings for the purposes of potentially dismissing 10% of damages is unjustifiable. I rest my case.
Justice O'Neill, do you have some points on this?
I would not be inclined to allow a motion in that scenario. It wouldn't, I can't see how that sort of determination could drive settlement in any way. And although there are a lot of protestations about the expense of proving lost profits, I just don't think as a practical matter, a litigant is going to hire a lot of experts and put a lot of time and effort into a 10% damages quantum. So I would be inclined to, I would deny the request.
I just want to add one thing, just from experience. I've had 2 cases where counsel did not make this application. And so we went through the whole thing. And in fact, but the argument was made at the end, right, in the final submissions. And so the tribunal actually did rule that they were not entitled to lost profit. So we just had this whole case presented and we kept thinking, why didn't they bring this up at the beginning? And we could have ruled and, they would have known how much this case was worth. So
And you're saying
sitting as counsel, if you have, a case where it seems appropriate, you might really think about at least making the application and see what the tribunal does with it. Because as I said, it's happened in 2 of my cases and we kept saying, why didn't they ask? Now, we didn't bring it up. So that brings us back to, should we be the ones bringing it up, which is kind of a dicey question, and people will go both ways on that also.
Well, and again, I would reiterate, let's take the 10% piece. if you request leave to file a dispositive motion on it, the other side protests, the arbitration panel denies the request, do track your fees that are attributable to the lost profits, discovery and trial, because at the end of the day, if that is decided as a matter of law, then you might be able to offset the award with the fees you spent on that element of the damages.
In arbitrator assessment, just to clarify, you're saying that in your case scenarios that you had, they didn't raise the summary disposition generally, not the 10%, right?
Well, I wasn't focusing on the 10%.
Yeah, so I just
10%
wanted
may
to
be
clarify.
different, but it just in general.
In general,
the
right?
idea-
That's what I was
it
just trying to
general
clarify.
Question. Yeah, no, it wasn't a 10% issue. It was, it would have been, most of the claim, they ended up getting their out-of-pocket direct costs and they didn't get the lost profits because of the limitation of liability. And they didn't bring it up. So it was, $80 million versus $500,000. It was quite a difference.
I'm just going to say, just because we'll be producing something after, if you just do the poll on this, just to get a feel for how the audience and those
that's right.
watching virtually,
So
although you've now heard from members of the tribunal.
all right, so a poll for this last sub scenario. Would you allow for a summary procedure regarding this 10%? So we got 2 online. Did you get 1 online?
Oh, really?
2 of them. Okay. Okay, so now on to the last big scenario. We have claimant alleges that respondent oil company and claimant enter into a land contract where the oil company purported to sell and transfer land to the claimant. Claimant files a case against respondent oil company for a breach of contract based on the land where the respondent oil purported to sell and transfer the land. Respondent files an answer and a motion to dismiss or early determination based on a lack of standing. Respondent argues that respondent never signed the agreement and complained by the claimant. So now we're switching roles now. So now, Mrs. Burt, you have 4. So why don't you provide your basis on that?
Thank you, Mr. Arbitrator. The respondent has already had to expend significant time, effort, and resources to defend itself in these unfounded proceedings, even though it never signed or otherwise entered into the relevant agreement. Arbitration is a consensual mechanism which cannot be imposed on respondent. This case is therefore a prime example in which the esteemed members of the tribunal must decide to allow for the requested motion to hear the issue of consent first, establishing whether or not the agreement was signed or otherwise entered into would dispose of the entire claim. If the tribunal finds, as it must, that the agreement has not been signed or entered into by the respondent, then it must find that the lack of respondent's consent to the agreement, which contains the arbitration agreement, deprives the tribunal of any jurisdiction. This issue must be determined on a preliminary basis to avoid the respondent and indeed the claimant incurring unnecessary costs and time. If the tribunal decides in favor of the respondent, then that's the end of the matter. Establishing that the agreement was not signed or otherwise entered into is a straightforward question. The unsigned agreement and fact pattern really speak for themselves. This is a self-contained question which can be decided on basis of documentary evidence. No expert evidence will be required at all. Similarly, of course, the jurisdictional question is a self-contained legal issue which can be determined by this experienced tribunal on the basis of legal submissions alone. It is therefore patently unnecessary to consider the complex merits of these claims, including the factual patterns with respect to whether the respondent breached the agreement or not, if the agreement does not in fact convey jurisdiction on the tribunal or bind the respondent in the first place. Time and cost savings related to the merits are significant and hence clearly militate in favor of this application. And moreover, even if, which is of course very unlikely, even if the tribunal decides that the agreement was signed or otherwise entered into by the respondent, then resolution of this issue on a preliminary basis would nonetheless be warranted. It would finally determine the primary disputed issue between the parties, and that in itself would lead to a less contentious remaining proceeding, or indeed may allow the parties to consider settlement options. The tribunal is therefore requested to determine this issue of respondents' lack of consent to the arbitration agreement as a preliminary issue. Thank you.
Mr. Arbitrator, just a very quick rebuttal here. Representing the claimant, who is the yellow circle in the PowerPoint slide, in opposing this motion for early determination. There's two reasons why this early determination motion should not be granted. The first one is it would lead to no real cost savings and may indeed add to the costs of this proceeding. And the second being that this is not a matter, this is not a sub-dispute which lends itself to early determination. So briefly on the facts, the question is whether this contract was signed or otherwise entered into. It is not merely a question of whether the contract was signed. In fact, the contract was signed. It was signed by the claimant's wife. And the claimant contends that his wife was acting as his agent. So you can see there that there are already some complexities involved. The claimant will be advancing evidence of well, first of all, he'll be advancing legal arguments when it comes to questions of agency under applicable law, and also considerable witness testimony on this point. So on the question of cost, this isn't simply a question of hiving off a self-contained dispute. There will be considerable testimony which may even be duplicative of the testimony heard in the main part of the case to be heard in the early determination portion. And the second point I would make other than cost is that this is not a matter that lends itself to early determination in the claimant's view. This is not a limitation period point. It's not a point about whether notice was duly given. It's actually quite a complex question of whether an agreement was entered into. And with that in mind, it deserves to be left until the merit phase where it can be properly considered along with the other points in this important dispute.
All right, so now going to the audience. Should this question of standing be submitted for summary disposition procedure? Any hands for yes? So hands up for yes. Okay, and online? 88% saying yes, early disposition. So
There's a real difference between those who are present and those online.
so Mr. Dasser, would you like to add some points on this scenario?
Yes, thank you very much. I'd like to do so. At the outset, I made a distinction between summary disposition without a full hearing and bifurcation, right? And the issue of jurisdiction can be, but does not have to be, an issue that can be bifurcated. But in my view, definitely not an issue for summary disposition. You do not decline jurisdiction having heard half the witnesses or having read half the briefs, or not allowed another brief if the parties want to have the right to be heard. So we're talking here at best about the bifurcation. Right? Actually, in Swiss law, there's a provision saying that in general, the tribunal should decide the issue of jurisdiction at the outset if it is disputed. Doesn't have to, but is invited to take that as an issue for bifurcation. In practice, it depends on the complexity of the issues. When it is easy to then, if there's jurisdiction, also decide on the merits, then why bifurcate, give it the whole thing in one hearing? We heard that apparently the witnesses will be the same, so it might make sense to have that in the same hearing. What I haven't heard is to what extent it is urgent to get relief on the merits. It's a land dispute. I would be interested to look at what are the prayers for relief. If it's for specific performance, transfer of the land, which might be necessary for example, production or whatever, and it cannot be postponed another 5 years, in the worst case, then that might be an argument to say, well, let's deal with the whole thing in one go because time is of the essence. If it's about damages, it's more likely that they would say, okay, let's first hear the issue of jurisdiction, and if there's jurisdiction, and then go to merits. Of course, if the jurisdictional defense is frivolous and looking at it, it looks like, come on, issue of agency. I mean, we have written documents showing that the husband was well aware and the husband was behind the whole thing. Here again, it's a matter of it depends. But I would generally be inclined to grant a motion to bifurcate the proceedings and deal with the jurisdictional issue first.
Any other comments from?
Any other counter arguments?
I
No?
agree. I think, jurisdiction, unless it's so intertwined with the merits, or I guess the time element that you were mentioning, you shouldn't be making people pay for an entire proceeding if there's no jurisdiction. So I think that is the common view.
All right, well, thank you to our advocates. I know they had to prepare for this in a short time, so thank you for those arguments.
I think we're doing well in terms of time. So it just remains really to say a very warm thank you to the panel member and
Yeah.
okay. Of course, okay. You,
There is an element of these efforts having its concept and there is something coercive about saying someone, we're not going to let people. Arbitration is consensual, and we have this psychological feel, and I share it, although I overcame it when I was voting a little bit earlier, that we need to be softer. And the question, and Danielle mentioned Article 5 of the Convention, and the question I ask myself when this is proposed is it worth it if we're then going to have a fight later on enforcement? And my answer, untested, because I haven't had the courage or found a client who is sufficiently reckless to have a go, is this. It is a curial court or an enforcement court in a jurisdiction which of course has summary judgment. They all do. And assuming the arbitrators applied the same test that the judges would apply in that curial setting, is it really going to say it's a denial of natural justice for the arbitrators to have done what the curial court would do? And that is the elephant. It's a psychological problem that I suspect we all share. It's not a problem whether it's 10% or 90% of the damages, because we all know 90% you go for it and you have your bifurcation. But the point is you dig deep and you hear all the arguments. It doesn't have that word, which I think is the problem, summary. There's something about it. And England looks as though it's going to become one of the first, if not the first jurisdiction in the reforms to the Arbitration Act, which will expressly recognize what the Law Commission says is implicit, not sure they're right, already in the Arbitration Act, that there is indeed power for arbitrators to make summary, to use that word, determinations, unless the parties have excluded it. So it's not mandatory. I haven't seen the draft words, but you can see that state in its support, obviously, for arbitration is grappling with this interface between what is coercive, what is consensual. My own view is that I would be happy to argue the case in front of the London Commercial Court as long as the arbitrators have applied exactly the same test that the judges of that court would have applied in an analogous situation. Thank you for letting me get that off my chest.
Yeah, I mean, let me just add, and I think Harriet mentioned it, but it is useful to ask the parties what standard they should be applying in deciding the motion. And it does vary from jurisdiction to jurisdiction. And, some arbitrators say, well, we're not bound by any of that. We can do what we want. But I don't think that's the right approach. So I think finding out what standard you should apply and then applying it is going to make it more likely that a court will uphold it. There have been a fair number of cases in the US, long before the AAA rules that have said that there is the inherent power and have confirmed arbitration awards, or there was a summary adjudication of the merits that disposed of the entire case on a variety of different grounds. So the courts do look to see if there was a fair opportunity to present. And I guess one of the things that I hadn't mentioned that one should be careful of is if there's a request for a document exchange, if the party opposing says, you can't decide this, we at least have to go through the appropriate exchange of information. You ought to think about that real hard before you say, no, we're just going to go ahead. You might want to allow that so you don't have that obstacle to enforcement that you didn't allow a fair process.
And if I could just jump in very quickly on this point, international arbitration is typically international. So, I am uncomfortable with the suggestion made because generally the procedure that applies to the bifurcated proceedings or whatever motion is being proposed is either subject to the rules or subject to the procedural procedure that applies to that particular arbitration. It is not the court procedure. In a context of an international proceeding, even if the enforcement court is the English court, for one party to impose English court procedural rules simply because they think that the courts are more familiar with them against the other party's will is not appropriate. Of course, unless there's agreement, as was just said a minute ago, if there's no agreement, then that cannot be the right approach. And there must be the procedural rules for the arbitration must be followed instead. So that would be my view, rather than sort of hoping that the courts will go with their own rules, which is not what arbitration is meant to do.
Yeah, it's a problem if they don't agree. It's much tougher. So all the rules say is, manifestly, manifestly not enough. What does that mean exactly in terms of application?
Because the ultimate point is for the arbitrators to be bold enough to bring that up at an early stage.
Oh, no, you've got to
and
bring it up
ask the
before.
parties to address.
Absolutely.
Any other questions or any
May I add
observations?
a comment on this? We all agree that arbitration should be efficient and rather more efficient than it happens to be now. The question is how we do that. And when I listen to what has been discussed, I sense there are two ways how to achieve that. One is by motion practice, right? And hope that by means of motions by the parties, you add efficiency, right? The other one is, and that's what we on the continent, particularly in Switzerland, try to do, is active management of the case by the arbitrators. When the case management is efficiently done, motions might get redundant. Right? You don't need to have everything argued in all details. You don't need to have extensive document production. You don't need to have 20 witnesses on each side and all of that. You can at least nudge the parties into being more efficient than that. And when you achieve efficiency by management, it's probably better for arbitration than to try to, through motion practice, end the proceedings with preliminary determination or even summary disposition. Thank you.
Yeah, I just want to say that, it really speaks to having a very active first call with the parties instead of what one often still sees where, they're dispensed with even, or I had one recently, excellent arbitrators. The chair was great. The co-arbitrator was great. The first call with the parties lasted 5 minutes and the co-arbitrator complimented the chair afterwards for having kept it to 5 minutes. So I think the point Felix was making was really engaging with the parties extensively from the beginning and really actively managing the case. You can obviate a lot of issues and resolve a lot of issues and move the case along appropriately.
Okay, thank you. Well, I think at the end, I have made a promise that I would say something about the Green Pledge. Reed Smith, we signed up to that a couple of years ago, and you've seen the posters around for information on that. It's an important initiative that was started a few years back by Lucy Greenwood with the aim of significantly reducing the carbon footprint for the arbitration community. We're taking it seriously. I am a sinner and a repentful one because we have these badges which we're not supposed to have. So I apologize for that and take responsibility. I was not aware. We will reuse these, recycle them, but I won't sin like that again. But it's an important and a very important initiative. So I encourage you to support it. And just to end on the note, with a warm thanks to all of our panelists, both here in person and also attending remotely. Thank you very much, Harriet and Antonia. Okay.